Good morning and welcome to the third instalment of Gough Square Live. I'm Michael Coley and with me today is Jonathan Goulding. Today's edition is going to focus on identifying and prosecuting the correct defendant. This can be a really important issue, particularly where companies are concerned. In some cases, getting the defendant wrong can be fatal to a prosecution, so we hope to be able to highlight some of the issues which should help you to avoid the pitfalls which lurk around this area. As ever, we're running our live chat, which I'll be monitoring during the broadcast, so if you have any questions or comments, please do get in touch. We've had some excellent contributions from our viewers during previous broadcasts, so Jonathan and I are very much looking forward to hearing what you have to say and discussing your questions at the end of the broadcast. But for now, I'll hand you over to Jonathan.
Thank you very much, Michael. If we could put up slide 1, please. Today, we're going to be discussing a matter that is fundamental to the criminal process from the enforcer's point of view, and that is charging the correct defendant, ensuring that the right, not the wrong person, is before the court. We will be looking at particular technical difficulties that might occur with corporate defendants and the consequences if the wrong defendant is proceeded against. We will also look at the key wrong defendant cases that have come before the higher courts and flag up some obvious things that could be done to avoid the problem arising. Please, could you put up slide 2? The issues. It is obvious that in any criminal case, the correct defendant should be identified. If a prosecutor puts the wrong defendant before the court, then the defences are very simple. It is not me. It will be bound to succeed. The prosecution will be left with egg on its face, and the defendant will walk away on what some or many might think is a technicality. The main difficulties in this area have been when a group corporate structure is involved, and it is this type of case that has occupied the courts over the years. The case law has made a clear distinction between situations of a mistake of identity and a mistake as to the name of a defendant. If there has merely been a mistake as to the name of a defendant, otherwise properly before the court, there is unlikely ever to be a problem. Amendment will certainly be allowed to change the name. However, if the wrong person is before the court, no amendment can get the right person there. It will be the end of those proceedings. This may not be fatal if fresh proceedings can be started against the right person. However, it will be fatal if the discovery of the wrong defendant occurs after the expiry of the relevant time limits to institute proceedings. There is simply no power in criminal proceedings to amend a charge or information to substitute the correct defendant for the wrong defendant. There is no better way to illustrate this area than by looking at the key case law. These cases show that the difficulties are more acute when dealing with limited companies, particularly when a complex corporate structure is involved. They explain the distinction between mistake of identity cases and the misnaming cases. Above all, they show the fatal consequences of an incorrectly identified defendant discovered out of time. An interesting recent case we will look at is the Essence Bars London Limited against Wimbledon Magistrates Court case. The Court of Appeal Civil Division held in the context of amendments in the Magistrates Court that a corporate defendant can be identified by description, even if the name given would seem to be an incorrect identification. Please could you put up slide 3. The key authorities. Starting point, Marco Croydon Limited trading as A&J Bull containers against the Metropolitan Police. This case concerned an information laid against A&J Bull Limited for causing an unlighted skip to be on a road on the 25th of September 81. This was an offence contrary to section 139(4) of the Highways Act and could only be committed by the owner. The skip itself had on it the name A&J Bull. In fact, it was the property of Marco Croydon Limited, trading as A&J Bull containers. During the investigation, the prosecution had in their possession a delivery note in which the name of the owner was stated correctly. Unfortunately, the prosecution, apparently misled by the name on the skip, prosecuted A&J Bull Limited, which did not own the skip. Both companies were, amongst other companies, part of A&J Holdings Group, but each were separate corporate entities. At the hearing on the 11th of June 1982, sometime after the 6-month time limit in which to bring proceedings, Defence Counsel told the prosecution which company owned the skip. The magistrates are then granted an application by the prosecution to amend the name of the intended defendant. This was on the ground that there was no mistake of identity, but only a misstatement of the defendant's name. On appeal to the Divisional Court, Lord Justice Glidewell reviewed earlier authorities. There was a distinction to be held between an old case, where at the hearing justices substituted the name of the company for its manager, and two cases concerning people who were intended to and did receive the summons, but had simply been misnamed. In the former case, there was no power to make the substitution, and in the latter cases, there was power to amend to change the names to the correct ones. The Divisional Court agreed that the magistrates in Marco Croydon were correct in law by saying that where the wrong person is being summoned, amendment should not be allowed, but where the prosecutor has correctly identified the defendant but merely misstated the name, amendment should be allowed. The court went on to hold that the magistrates had applied the test wrongly by substituting Marco Croydon for A&J Bull Limited. They were separate corporate entities, and counsel for A&J Bull Limited was not instructed by Marco Croydon Limited. The defendant had been wrongly identified and the conviction was quashed. We now move from skips to bananas. In the next case, the Queen against Greater Manchester Justice Ex Parte Aldi GmbH. In May 1990, following a complaint, a trading standards officer in Salford went to Aldi stores in Swinton and Eccles and checked the loose bananas that were being sold in the stores. On one occasion, he bought bananas that were too expensive, and on another occasion, bananas that were sold too cheaply. Informations were laid against Aldi Stores Limited for alleged mispricing offences under Section 20 of the Consumer Protection Act 1987. Unfortunately, Aldi Stores Limited, an English company, was not the retailer selling the bananas. Aldi GmbH, a German company, was. When the matter was raised at trial in October 1993, the one-year time limit had expired. The prosecution made an application under Section 123 of the Magistrates Court Act 1980 to substitute the retail company Aldi GmbH for the wholesaler Aldi Limited. This was permitted. On appeal, Lady Justice Butler-Sloss held that the court was bound by the decision in Marco Croydon, and that the decision was on all fours with the case before them. The two entities were separate companies with separate functions, and the defendant company before the justices had a complete defence to the summonses that were taken out against it. This was a case where the company who had to meet the allegations contained in the summonses was simply not before the court at all. This was not merely a case of misdescription of the same person. Accordingly, the appeal was allowed. The amendment should not have been permitted. Interestingly, the other judge in bananas, Mr. Justice Latham, as he then was, said that Section 123 of the Magistrates Court Act 1980 is a restricted power. It is the only statutory power available to a magistrates court by which the form of a process can be amended. It applies where a defendant makes objection to the information. It follows that Section 123 has no applicability where the defendant before the court was simply saying, "It was not me who committed the offence, it was someone else." This is not an objection to the form of the information, it is a defence to it. He said that the consequence of allowing an amendment to substitute a different entity, and I quote, was to have an amended information charging out of time an offence against a different defendant. There is no power to do that. The third case of note is Sainsbury's Supermarkets Limited against Her Majesty's Court Service. We move from skips to bananas to donuts. This case concerned a dodgy jam donut purchased from a Sainsbury's store in Plymouth. An allegation of unsafe food was made. The donut was purchased in August 2004 and the information laid in August 2005, one day before the limitation period expired. The case was heard in December 2005. The defendant was named as J. Sainsbury's plc, open brackets, trading as Sainsbury's Supermarkets Limited, close brackets. There is no such company at all. The correct names of the companies are J. Sainsbury's plc, a holding company, and Sainsbury's Supermarkets Limited, which is the actual retail company who would have been the correct defendant in the case. At the hearing, the district judge allowed an amendment by substituting the correct name of Sainsbury's Supermarkets Limited for J. Sainsbury's plc, trading as, open brackets, Sainsbury's Supermarkets Limited, close brackets. The appeal was allowed on the basis that effectively the judge had proffered a charge against a new defendant outside the statutory time limit. So, in the 3 divisional court cases, a clear principle has been established. There is no power in the case of a wrongly identified defendant to substitute it by amendment with the correct defendant. In each of the 3 cases, there was a complex corporate structure. In each, the prosecution identified the wrong company and paid the price by finding out when it was too late. The Skips, Bananas, Donuts trilogy has been considered in our 4th case, Essence Bars London Limited, trading as Essence, against Wimbledon Magistrates Court, a 2016 case. The Royal Borough of Kingston-upon-Thames revoked the premises of a nightclub, the premises licence of a nightclub called Essence. The provisions of the Licensing Act 2003 allowed the premises licence holder to appeal by way of complaint to the Magistrates Court within 21 days of being notified of the decision. The holder of the premises licence was Essence Bars London Limited. The solicitor acting for the nightclub in the complaint document mistakenly named FL Trading Limited as the complainant. However, in the body of the notice, it said that the complainant was the premises licence holder, intended to appeal against the decision. The case has had a convoluted history. Wimbledon Magistrates Court and the High Court ruled that the magistrates had no jurisdiction to hear the appeal. They said FL had no standing to appeal under the Licensing Act, and the strict 21-day time limit for appealing had expired. Both the Magistrates Court and the High Court considered themselves bound by the trilogy of earlier cases. The mistake was deemed to be one of identity rather than description, i.e. the naming cases, and could not be remedied under section 123 of the Magistrates Court Act by substituting Essence for FL. The Court of Appeal's Civil Division allowed the appeal. Lord Justice Beatson identified the relevant test as being A, whether it is clear that there is no mistake as to identity, and B, that the other party is not in any reasonable doubt about this. The court took the view that Essence Bars Limited was distinguishable from the 3 divisional court cases. That is because the appeal notice in the Essence case expressly included a description of the appellant as the premises licence holder, as well as the use of the corporate name. Lord Justice Beatson said that there is no automatic rule that a mistake concerning a corporate entity is a mistake of identity, or that where a name and a description is used, it is the former rather than the latter which identifies the parties in question. Thus, where a name and description were used in a document, the description could be used to identify the party. The mere fact there were 2 corporate identities involved did not mean that there was a mistake of identity which could not be corrected pursuant to the amendment powers in section 123. If the court is satisfied that there is no mistake as to identity, then the other party must not be in any doubt about it. This would be a matter of evidence, such as letters and documents showing the licensing authority in the case knowing that Essence was the premises licence holder. Essence was duly remitted to the Magistrates Court for a fact-finding exercise applying the Court of Appeal's new test. Could I have the 4th slide, please? The judgment, in essence, is not restricted to civil proceedings because it applied to Section 123 amendments in the Magistrates Court. However, it is unlikely to stop defendants wishing to take the wrong defendant point and true mistake of identity cases like Skips. They will still be fatally flawed. It is likely, however, though, that a court now confronted with a wrong defendant argument will now be asking itself whether A, it is clear that there's no mistakes to identity, and whether the other party is not in any reasonable doubt about this. It is a case that may assist enforcers who have made an error in the framing of their information or charge, but it would be hoped that they will not find themselves in that situation in the first place, when it's a mistake that should not be made. So in conclusion, let's look at what one can do to get it right. Do not correctly identify the defendant. Wrong defendant challenges may ruin a very good case on its merits. Getting it right going forward means checking corporate structures carefully. It sounds basic, but it needs to be done. Who is the trader, producer, supplier or seller? Check trader details carefully, and the disclosure requirements by traders under Section 85, check they're complied with. Clarify as much as possible any doubts as to identity at interviews under caution. And finally, do not undo all the hard work by putting the wrong person in the dock and only finding out when it is too late.
Well, thank you, Jonathan. Some very interesting points raised there. We'll have a look to see whether anyone has asked us any questions arising out of that. We've had a couple about the sound. I know we've had a few issues during the course of this broadcast, which hopefully we will look at afterwards and we'll have ready for next time. But hopefully everyone's been able to pick up the points as they've been coming out and was able to hear the presentation and see the slides. Not very much on the live chat by way of questions about defendants. I'm just wondering whether we have any which have come in by email. We'll have a look. And I think, Jonathan, you've done a very good job explaining the issues today, because we don't have any questions just as yet.
Well, I suppose it's just pointing out, Michael, isn't it, that these are matters that the enforcer needs to be aware of, and I think after many years, the lesson has been learned, because in my sort of experience at the bar, while these cases were all being decided, we used to see it fairly regularly that a mistake was still being made, and it is something that is, I think, fairly basic.
Yes, and it's very much a case of being aware of how these corporate structures work and the basic company law issues that come into play. We have had a couple of questions come through, in fact. First of all, does the most recent case, I think they're referring to the Essence case you spoke about most recently, does that case mean that the prosecutor, concerned about the identity of the defendant in a complex corporate structure, could include a description of the defendant in the information in order to prevent potential issues over identity? What are your views on that?
Well, I suppose it could be done, but whether that's going to help is another thing. It might actually demonstrate that they're unsure of the identity of the person, and it might be that they get lucky and identify the right person, but I don't think that's the answer. I think you need to be precise, and I don't think that would be a good tactic.
We have another question, which is, what happens if a prosecutor names an incorrect human defendant, for example, a sole trader?
Well, I think it's more straightforward when you're dealing with a person, because it's either the right person or it's the wrong person. It might be the right person using an alias, but it will be the right person. If they wanted to charge Jonathan Goulding and you turn up, then clearly that's the wrong person. But if I turn up and call myself Michael Coley, then the amendment can be made to substitute my correct name.
The issue
is the right person before the court, whether it's a sole trader or a company. That's the issue.
And if it's simply a question of his name being misspelled, or
if it's the wrong, yes, then it can be amended. If it's the wrong person, they'll simply say it's not me. It was Michael Coley what done it.
We have a question through on the live chat from Green Rider. What tips can you give that can help clarify the situation when conducting an interview under caution?
Well, the starting point is they don't have to answer any questions, so they could come along and not help you at all. But I think you would be asking them questions along the lines of, are you the company that has been selling these goods? Who's responsible for the supply? Who's responsible for selling? And establish that. And I've seen that done fairly often in interviews under caution, where the trader has been established in interview. But by the same token, I've also seen it where there's been a mistake made in interview by someone who's turned up purporting to act on behalf of the company and has given, whether genuinely or disingenuously, the wrong information.
And I suppose it comes down as well, I think, to the preparation you carry out before the interview as well, doesn't it? In terms of identifying what the corporate structures are and who is who in relation to the different companies. That actually leads on to the next question, I think, which we've received from Alison in Essex, which says, is Companies House still the best place to go to find out the information on the identity of companies and company directors?
Well, they should all be registered there, shouldn't they? Whether that's going to be any help as to who the defendant in a particular case is another matter, and it'll depend on the facts of the case.
Very good. I think that those are all the questions we've had through so far. So thank you very much, everybody, for joining us today. We hope you found today's talk useful. You can join us again in 2 weeks' time, that's the 31st of August, in our usual slot at 11 o'clock, when I'm going to be joined by Cameron Crowe, and together we'll be looking at the recent Supreme Court decision in the case of C and others, which is an important case concerning grey market goods, and will be of interest to anybody who practices in the field of intellectual property crime. In the meantime, please feel free to contact us if you have any questions or feedback, or if you have any suggestions for future topics you'd like to see us cover on future shows. You'll find our email address on the final page of your handouts, which were sent out before today's broadcast. So we look forward to seeing you next time. For now, though, from everybody here at Gough Square Live, thank you for watching and goodbye.
Goodbye.